Hi, this is Al.Otto, and I am here with Bruce.Ashton from
Hi, everybody.
Bruce, I hope you're doing well today.
Just living the dream.
Awesome. And we're all living the dream here in the COVID arena, right? And
exactly.
We are just so honored today, really, to have you really to talk about trends with 457B plans in California. And
my pleasure.
For those of you that don't know Bruce, he has 35 years of legal experience at least. And, I've known Bruce a long time, and he is an esteemed legal counsel to registered investment advisors, to record keepers, to plan service providers, broker dealers, insurance companies. I think, Bruce, at some point you've probably worked with everybody on every side of the chain. But you also, as I understand, you both advise and defend fiduciaries on their obligations and liabilities, and we're going to talk about that a bit today. And you work with both public sector and private sponsors to negotiate resolutions of plan qualification issues. I'm just excited to be talking to you, quite frankly.
Well, I'm just thrilled to be here. I appreciate the invitation. Cool. And this is an interesting topic that we're going to cover today.
Yeah, it's a little bit esoteric until you realize how many people are employed by governmental entities all over the country, and especially in California.
Exactly.
This affects a lot of people. So. But I'm gonna jump right in now. Bruce, you wrote a paper a while back called "Fiduciary Duties and Obligations in Administering 457 Plans Under California Law." Now, you wrote that a while ago. What's different? What's changed?
Well, frankly, not much. And I went back and looked at that paper again and was very impressed with how wonderful it was. But I also took the opportunity to look at the state of the law in California just to see if anything had really changed. And frankly, in terms of the legal requirements under California law, they really haven't changed. And maybe it's appropriate at this point to talk about why we're just talking about California law, and it may be that the members of the audience are already very well aware of this, but the main law in the U.S. dealing with retirement plans is ERISA, the Employee Retirement Income Security Act, and it's a federal law. But that federal law specifically says it does not apply to governmental plans. So that means in terms of 457 plans, for example, we look to the state law with respect to issues that are not covered by the Internal Revenue Code. So in California, there's a specific government code section that says that 457 plans are subject to some rules under the California Constitution. And that may sound a little bit weird if you're not already aware of it, but the California Constitution has a provision that is really quite similar to the fiduciary provisions of ERISA. And it basically says that the governing body of a plan, including 457 plans, have a duty to invest the assets of the plan. They have a duty to administer the plan. And they have a duty, and this may sound for people that are maybe somewhat familiar with ERISA, this is going to sound exactly like ERISA, and it's in fact modeled after the ERISA provisions. They have a duty to act for the exclusive purpose of providing benefits to the participants. And it also goes on to say, in words that are almost exactly identical to ERISA, that they must engage in a prudent process for making all decisions especially regarding investments and services. So those are the main duties. Administer the plan, act for the exclusive purpose of providing benefits, and act prudently in making decisions.
Bruce, I know that certainly the duties and obligations sound to be very similar. Are there things in ERISA that are key that are not also included in the California law?
There are some, and maybe it would be good to talk about some of those a bit later, but there are some differences, for example, in the concept of brokerage windows and that sort of thing. But for the most part, they're very, very similar under ERISA and the California constitutional and state law provisions. One other aspect of this fiduciary duty that I need to mention up front is that there's a provision in the government code that also reminds the governing bodies that not only do they have these obligations to act prudently at the front end, but they also have an obligation to revisit their decisions periodically. And we refer to that as the duty to monitor. Right. The prudence requirement says that you have to act prudently under the circumstances then prevailing. Well, what that's getting at is circumstances change, and that means you need to revisit your decisions periodically, including decisions on what investments are being made available and what service providers are being used, or potentially even renegotiating with service providers if you're happy with the service, but you might want to look at the costs that they're imposing on the plan.
Right. Well, so operating a plan in essence, under ERISA regulations, that's not a normal or usual thing elsewhere in the country for governmental plans. What are some of the issues that you see come up?
Well, I think the issues that I want to talk about, sort of the current issues, we're seeing a lot of, and we have seen in the last decade and a half to 2 decades, and a substantial explosion almost of litigation involving plans. And there's a very well established plaintiffs class action bar that brings these lawsuits, and they started out mainly involving 401k plans, mainly involving very, very large $1 billion plus plans. But over the period since these cases first started, they've both expanded the types of plans where there's litigation, and they've also come what I'll call down market to smaller plans. And one of the main issues that's looked at is cost. And the claim has been that the plan fiduciaries, in the case of a 457 plan, it would be the governing body, has not acted prudently in terms of making sure that the costs that are borne by the plan and therefore by the participants in the plan are reasonable, are favorable to the participants. That essentially the argument is you fiduciaries have permitted the costs to be too high. And the effect of that, obviously, if that is true, is to erode the retirement savings in these types of plans for the participants at retirement. And so basically, one of the issues that I think people need to be aware of, even if this isn't necessarily specified in the law, or even if there hasn't been specific litigation against, very much litigation against 457 plans, there is this issue of watching the costs that are being borne. And when I say costs, what I mean is the costs of the investments. What are the internal costs of the investments, and what are the costs being paid for services, and those need to be reviewed periodically under this monitoring concept. And one of the best ways to review those costs is to get what's referred to as a benchmarking report. That is a report that takes data from thousands and maybe hundreds of thousands of plans around the country and compares the services versus the costs and the investments versus the costs, and using that to look at then what's going on in the plan for which you're responsible, and saying, well, gee, am I overpaying for these costs? Can I get a better deal? Should I be looking at different investments that have a lower cost?
Right.
So that's one of the current trends that I think people need to be aware of. Another one that is starting to become a trend, if that makes sense, is looking at the participant data in the plan and saying, gee, if the plan permits service providers to make use of that data to market other services to the participants, that's may or may not be appropriate.
Right.
So I'm sorry, go ahead.
Plan asset or something like it would be treated as a plan asset under that?
Yeah, that's the argument that's been made, and so far there haven't been very many cases that address this. Although the cases that have been filed are expanding, but the only decided case, a federal district court judge said, no, the participant data is not a plan asset. On the other hand, there have been a handful of settlements in which the parties, the plan providers have agreed, yes, it is a plan asset. So it's kind of up in the air as to whether it's a plan asset or not. But the point is still, I think, an important one, and that is, if there's value to the participant data to a service provider because they're going to take that data and market other services that are not related to the plan, presumably that has some value to the service provider, and therefore the plan fiduciaries need to think about, well, gee, if it's got some value, should we negotiate a lower fee for the services they're providing to the plan?
Right.
Or conversely, should we just say, you can't use this data for any other purpose? You may only use it for plan purposes. And I don't have a view as to which one of those is the appropriate way to go. But the point I'm trying to make is that it is an issue that needs to be thought about, be considered.
A prudent plan sponsor should be asking questions of, how much additional revenue are you making on our participants' data?
Yeah, that's one possible approach. Or saying to themselves, gee, if I permit a service provider to offer other products or services, am I effectively kind of giving a tacit endorsement to those other products and services? And therefore, could I be held responsible if a participant has a problem with those other products and services?
Right.
So given that concern, some fiduciaries have said, no, you can't use the participant data for anything outside of the plan. So it's, those seem to be the two choices. Either say, yes, you can use it, but you have to give us a break on costs, or no, you can't use it at all.
Sure.
I mean, maybe there's some other ground, but I don't know what it is yet.
I'm sure there are all kinds of possibilities there. Well, so if increased litigation in this arena is an issue, we've talked about a couple of things that in our previous conversation about confusion, basically. So one of the things we talked about was, plans in the 457 world sometimes have, in essence, multiple plan documents. I suppose that's possible because it exists, but what are your thoughts about having multiple plan documents, and if you wanted to have just a single document, how would you do that?
Well, I think you've raised a really good issue, and I think the word you used a minute ago about this particular issue of multiple plan documents, the word you used was confusion. And that always worries me when I see a plan sponsor have multiple documents, because you then have to have, some really good system for saying, okay, which document am I operating under for this group of employees or this particular employee?
Right.
And it can be very confusing and lead to problems if you're looking at one document but another document controls. So what I generally like to suggest is, let's create a standard document that is fairly general, but then it creates the possibility of providing for different benefit structures for different employees or different groups of employees. And that can be handled by way of a document that is given by the plan to a specific employee, or is adopted for a group of employees, that says, okay, here are the benefits that are going to be specifically offered to this group of employees. We're going to have a match on deferrals, for example, or we're not going to have a match, or the match is going to be 100% of deferrals up to 5% of pay, or it's going to be some other formula. In other words, setting up different structures of that sort by having addenda to the plan, or by having, a separate document that references the plan with a given employee. So to me, that's a safer way of approaching it.
It sounds like the best way to do this is have a single document that is open enough to allow for what you want in your plan.
Yes.
Okay. And so one other thing in this arena of ERISA that I've seen that I'm anxious to hear your answer to. So I have seen sales practices, right, where people are actually, even plan sponsors are saying, we need to have a 338 investment advisor on our 457 plan. So first of all, you and I both know 338 is an investment manager, not an investment advisor. That applies to a different part of the rules. And 338 is an ERISA concept.
Right.
I think what people are asking for is a discretionary investment advisor, but they're calling it a 338. Does that create potential liability for either the sponsor or the investment advisor or whoever is doing that?
Yeah, let me give just a little bit more background on when we talk about 338. There's a provision of ERISA that applies to plans that are subject to ERISA, but obviously not to governmental 457 plans. And that provision says that banks, insurance companies, or registered investment advisors can serve as a discretionary investment manager of the assets of a plan. And there's another part of ERISA that says if they do so, that removes responsibility from the main fiduciaries of the plan. It shifts the responsibility for the selection of investments over to this 338 investment manager. So I think that's what people are looking for in the context of a governmental 457 plan. It doesn't bother me particularly to use the term 338, as long as people understand what it's referring to, and what it's referring to is a investment advisor that is given discretion over plan assets. And strictly speaking, that isn't something that's provided for in the California law. On the other hand, it strikes me that it can be made to work, but it means that the governing body of the 457 plan, in exercising their fiduciary responsibility to act prudently, has a little bit more of an obligation. In the ERISA context, what happens is the obligation to prudently select and monitor investments is shifted over to the investment manager, the discretionary investment manager. And that could be done by way of contract in a 457 plan, but I would want to make sure that the governing body does two things. First, they have to, really vet, that is, look at the credentials, look at the how this firm has operated, how other people have reacted to the firm. Does it get good references, or does anybody have anything bad to say about them? So go through a thorough vetting process for that discretionary investment advisor. But also, I think they're going to need to take on more of an obligation to look at, okay, what investments is this a discretionary investment manager selecting, and do a more in-depth monitoring process of those investment choices than would be required if it were an ERISA plan.
Well, fiduciary duty in California is clearly something for plan sponsors to pay attention to. And recent litigation is also something that needs to be clearly paid attention to. So, Bruce, we thank you very much for your insights. As always, we really appreciate you listening to Verity Shares. If you want more information or want to contact Bruce or me, you can reach us at the email or phone numbers below. I'm Al.Otto for Verity Shares. Have a great day.